In an attempt to explain why corruption charges against former Transport Minister S Iswaran under the Prevention of Corruption Act were dropped, the Attorney General's chambers cited challenges in prosecuting him under the Act. The AGC argued that proving corruption would be difficult, given that both Iswaran and property tycoon Ong Beng Seng would be unlikely to implicate themselves. This explanation is surprising, given the provisions of Section 8 of the PCA. For those charged under Sections 5 or 6, the law presumes corruption once a public officer receives any form of gratification, placing the burden on the accused to disprove corrupt intent. Since Iswaran was charged with 2 counts of corruption under Section 6, read with Section 7 of the PCA, the legal framework should have facilitated, rather than complicated, the prosecution's task in this case. More perplexing is the AGC's decision to amend the charges, ultimately charging Iswaran under Section 165 of the Penal Code rather than under the PCA, effectively removing the corruption charges altogether. Notably, this is the first time in Singapore's 153-year history that Section 165 has been invoked. Section 165 addresses the acceptance of valuable items by public officials without requiring proof of corrupt intent, and it carries significantly lighter penalties, just 2 years imprisonment, compared to the 7 years possible under the PCA for corruption charges. While the AGC cited litigation risks in proving the PCA charges beyond a reasonable doubt, this explanation seems to sidestep the fact that the PCA presumes corrupt intent once gratification is accepted by a public official. The AGC also stated to the media, AGC also considered whether the amendment would lead to a fair and just outcome that is in line with the public interest. But is the public interest better served by reducing the severity of the charges? Or does this decision represent an overly cautious approach to a case that, on the surface, appears to meet the conditions for prosecution under the PCA? The AGC's decision becomes even more questionable when considering the total value and scope of the gifts involved. These gifts, valued at over 218,000 Singapore dollars from Ong alone, were not casual or one-off gestures, but involved high-value items, including tickets to the Singapore F1 Grand Prix, football matches, and exclusive theatre performances, alongside luxury golf equipment, expensive whiskey, and a high-end bicycle. From November 2015 to December 2021, Iswaran allegedly received 24 valuable gifts, exceeding 384,000 Singapore dollars in value from Ong, often tied to the business dealings related to his official role as chairman of the F1 steering committee. Similarly, between November 2021 and November 2022, Iswaran allegedly accepted several expensive items worth 18,920.94 Singapore dollars from David Lum Kok Seng, managing director of construction firm Lum Chang Holdings, including whiskey, wine, and golf equipment, during a period when Mr. Lum's company was managing a major contract for the Land Transport Authority. Iswaran did not merely receive a token gift on a single occasion. He received a series of high-value items over several years, all from individuals with business interests directly tied to his official roles, raising significant concerns about conflicts of interest. Given the substantial value and frequency of these gifts, Iswaran's acceptance of them is far from a minor infraction that Section 165 might traditionally address. This is especially concerning when considering that civil servants in Singapore are prohibited from retaining gifts worth more than 50 Singapore dollars and must declare any gifts received from external stakeholders to their permanent secretaries. Iswaran's failure to report these substantial gifts only heightens concerns about the AGC's decision to amend the charges to the lesser offence. While the AGC's caution in considering litigation risks is understandable, the presumption of corruption under Section 8 of the PCA would have shifted the burden to Iswaran to prove that these extensive gifts were not corruptly given. In this context, the unprecedented use of Section 165 seems out of place, given the clear legal mechanisms provided under the PCA for such cases. A comparison with the case of Wee Toon Boon, the former Minister of State for the Environment, is instructive. In 1975, Wee was found guilty on 5 charges of corruption, similarly under Section 6 of the PCA, and was sentenced to 4 years and 6 months in prison and fined 7,023 Singapore dollars, later reduced to 18 months upon appeal after a 3-year sentence for one charge was quashed. The judge ruled that Wee had failed to cast reasonable doubt and concluded, on the balance of probabilities, that he accepted gratifications as rewards for favors shown. Notably, Wee received a 6-month sentence simply for accepting 3,500 Singapore dollars, roughly 11,410 Singapore dollars in 2023, adjusted for inflation, worth of galvanized roofing for his house. Given the overlapping relationships between Iswaran, Ong, and Lum during Iswaran's time in office, and the undeniable acceptance of extravagant gifts, it raises the question, why is it considered challenging to prosecute Iswaran, given the presumption of corruption in Section 8 of the PCA? Considering the above, Deputy Attorney General Tai Wei Xiong's assertion in court that there was a strong basis for originally bringing the corruption charges appears valid. Therefore, it is baffling and difficult to understand why the AGC chose to withdraw the charges at the 11th hour, citing possible difficulties when the burden of proof is not on its side. Equally puzzling is how Iswaran, after professing his innocence for months, so unexpectedly agreed to plead guilty to the amended charges. Public expectations for transparency and accountability are understandably high in a case involving a senior public official. The decision to downgrade the charges, particularly when stronger anti-corruption laws were available, risks undermining public confidence in the judicial process.